You're recognized.
Thank you, Mr. Chairman, and thank you to all of our witnesses for appearing here today. I appreciate that. Recently, workers at the Volkswagen plant in Chattanooga, many who live in my neighboring 4th District, voted against unionizing their workforce. It was encouraging to see a free and robust debate concluded by a fair secret ballot election. Workers deserve access to a broad spectrum of ideas with which to make their decisions whether or not to unionize. Unfortunately, under the recently proposed rules, future debates like these could be limited, forcing employees to make incredibly important decisions without the benefit of full accounting of the facts. Mr. Messenger, under current law, what can a union do or say to employees during an organizing campaign?
Effectively anything that's not a direct threat. Board law provides that if a union makes a promise or a threat, it's only considered actionable or objectionable if the union can actually carry it out, the threat. And the board has held that if the union makes promises about what it's able to do, the union's not actually able to do it. It's contingent upon future bargaining. So a union is effectively able to promise virtually anything it wants or predict any dire consequences that it wants as the result of unionization. Basically, one of the few things the union can't do is directly threaten an employee because it could carry that threat out. But other than that, the union is generally free to state whatever it likes about future consequences of unionization.
What resources do employees have to kind of separate the facts from the rhetoric?
Only information that they receive from other parties, their coworkers for one, but also a very important source of information is their employer. And under these rules, the employers have very little time to prepare for a campaign and get out information, which is particularly difficult for employers because, unlike unions, there's a host of restrictions on what employers can say. It's a virtual landmine or minefield of things they can say wrong that could be considered unfair labor practices or that taint the election. And so they need to hire labor counsel and all the rest to prepare to be able to get out what information they can. And these rules significantly shorten the time frame for them to be able to do that and thus diminish the amount of information that employees have available to them.
Okay. In your experience, do unions routinely provide employees they seek to organize information about itself or themselves?
Only favorable information that presents them in a good view. Unions are ultimately campaign organizations, and it's what they do there. It's what they do for a living or as a business, and so they test what they do, and they only present what they think will be effective in ultimately getting an employee to sign a card or to vote for them. They're under no obligation to provide any other information about the downsides of unionization or anything that's even fairly or balanced.
Okay. Do you find that they would usually disclose their constitutions, their bylaws, results of unfair labor practice charges, results of negotiations for first contracts, past records with other employees, bargaining history, or things of that sort?
No, unless the union believes that one of those facts it can cherry picks out will make it look favorable to the employees it's trying to unionize. But it certainly doesn't fully disclose the pros and cons of unionization, only the pros.
Ms. Davis, would you add anything to that?
I would certainly agree to that based on my experience. Normally, the responsibility for educating the employees about those list of items that you just read off rests with the employer, not with the union.
Okay. That's all I have.